Hello everybody, thank you for joining us today. My name's Neil Smith, I'm the Head of Dispute Resolution at LexisPSL, and you're joining us today for a roundup of some of the key decisions that have arisen since the Jackson reforms, which is, depending on when you're watching this, either almost a year ago or just over a year ago. We're really fortunate today to have a fantastic panel of speakers alongside me. They're all members of the LexisPSL Dispute Resolution Editorial Board, so they obviously come highly recommended. As you'll be aware, as practitioners, it's been an extremely busy year. Lots of new rules, lots of interpretation of new rules, still some uncertainty, still a bit of indecision as to how best to play things from a tactical point of view. If I may be forgiven for mentioning the product briefly, on LexisPSL DR you'll find a lot of guidance, you'll see some cost budgeting videos. We've got our very own Mark Sergi here, who participated in the cost budgeting videos alongside Judge Simon Brown. Do have a look at that. Before I introduce my panel, just very briefly, to give you an idea of how topical and how much of a hot topic Jackson remains, the fact that only yesterday, the day before recording, there was the interesting decision of Rattan, which dealt with an argument that a cost budgeting was delayed in filing. As it turned out, the court found it was the commercial court held that there wasn't a delay, but do take a look at that on the product. So, over to introducing the panel. So over on my far left, we've got Keith Levine. Keith is a cost lawyer and is the head of Pinsent Mason's law cost team. He also has rights of audience and rights to conduct cost litigation as a cost lawyer. He's a practicing member of the Academy of Experts, an accredited mediator with CDR, a member of the Association of Cost Lawyers, and as if that isn't enough, as I've already mentioned, he's also, best of all, a member of our editorial board. So thank you, Keith, for joining us. Immediately on the left of me, we've got Ed Pepfall QC. Ed is a commercial silk dealing in multi-million-pound litigation claims. He's a member of St. Philip's Chambers. I should also mention, and this is particularly relevant to today's chat, that he's a member of the Civil Procedure Rule Committee, so I hope you don't mind us pumping you for some inside information today. He regularly gives seminars, webinars and TV interviews on both procedural and substantive law, lead advocacy tutor for Lincoln's in teaching, and Ed also sits as a recorder. So on my right, we've got Mark Sergi. Mark is a partner in Evershed's Fraud and Investigation Group. He's litigated in private practice for 25 years and is well known for his involvement in complex and challenging cases involving large volumes of electronically stored information. So I'm not just saying this, I'm delighted that we've managed to put this panel together because I think it's a really interesting spread of expertise and an interesting spread of disciplines as well. Just before I hand you over to our panel, just to explain, Keith's going to be talking about costs and funding. Eddie's going to be talking a little bit about the changing culture overall, which I think is especially important, and including relief from sanctions. And Mark is going to give us some frontline experience as a partner in terms of disclosure and those sorts of issues and top tips. So, thank you for joining us. Over to Keith.
Hello. The change in funding really since April 2013 revolves around sharing risk, sharing litigation risk. And that involves really lawyers or clients sharing risks together, clients sharing risks with insurers, clients sharing risks with funders. And it's a question of how you bring all those things together to create opportunity for lawyers and to create opportunities for clients to be able to bring claims successfully, hopefully. Post-April 2013, you obviously have LASPO, Section 44, dealing with CFAs, Section 44.6 of LASPO in particular, dealing with the non-recovery of success fees, the CFA Order 2013, and in particular the saving order, which in effect carved out where success fees would still be recoverable, as they have been in the last year. The saving provisions in effect covered three particular areas. It covered insolvency cases, publication and privacy cases, and mesothelioma claims. The key question is, well, what's really been happening over the last year? What have people been doing with CFAs? Well, in truth, CFAs have continued. CFAs will continue. CFAs are a way whereby lawyers can share risk with clients, and clients in effect can bring litigation hopefully in a way which means that they are paying less money up front, but in sharing that risk they pay more if they're successful. And it is a question of balancing risk. Therefore, you'd have to look at the types of CFAs that really have been in play in the marketplace in the last year for a number of years and will continue to be in play. The types of CFAs that lawyers will enter into will be full CFAs, traditionally known as no-win, no-fee agreements. Fair to say in the commercial arena, they really are at the lower end of what people are doing. Most lawyers do not, in commercial litigation, have an appetite for doing no-win, no-fee work. Most CFA work in the commercial arena is under the hybrid arrangement whereby a lawyer agrees to put part of his fees at risk in return for reward. And that incurs, in effect, a sharing relationship with the client. The way the risk is shared is quite simply, and a simple example would be the lawyer would say, I'll take 60% of my fees come what may, I'll put 40% of my fees at risk, I will postpone 40% of my fees. In the event of success, I would charge you the 40% postponed fees, but I will also take a 40% success fee. In other words, if the client is unsuccessful, the client only ever pays 60% of the fees and his disbursements, and the lawyer bears the risk of the 40%. But conversely, if the client is successful, the client then pays the 40% postponed, and there may be 40% on top, balancing risk with reward. So the lawyer walks away with 140% fees in that scenario if he's successful. In my experience, most commercial clients understand that as a commercial relationship. If you say to me, has it made a difference since April 2013 that the client can no longer recover the success fee element from the opponent? In truth, it's made absolutely no difference whatsoever. I would say in the last 8-9 years, however long it's been that I sit down with commercial clients and talk about CFAs, no commercial client ever asks the question, will I recover the success fee from the opponent? So far as commercial clients are concerned, it's a question of, will I win? How do I resolve my commercial dispute as quickly as possible? Generally speaking, lawyers are not sitting down with clients and saying to them, you've got a large commercial dispute, it's going to run for 18 months, 2 years, and at the end of it you're going to have a detailed assessment. A, that's not a conversation you want to be having because you want to be explaining to the client how you resolve the dispute. Secondly, in commercial litigation, very few matters ever end up with a cost recovery. Most commercial matters tend to settle inclusive, and even when there is a cost recovery, those cost recoveries tend to settle and only a minute fraction ever go anywhere near the cost office for a detailed assessment. What's going to happen going forward with these CFAs? I should say that in addition to hybrids, there is also the question of CFA lights, L-I-T-E-S, the type of CFA where lawyers will put part of their fees at risk or all their fees at risk, and those fees will be at risk and only payable against recovered monies. An arrangement which lawyers are permitted to do, provision within CPR 44.2. It's a question there of whether lawyers are willing to, in effect, take on risk as to solvency of the opponent by putting part of their fees against recovered monies. In most cases in commercial CFAs, the element that tends to be put against recovered monies tends to be the postponed costs, not the base costs which are payable in any event. Counsel also obviously take on CFA work. 10 years ago, there were very few counsel who were willing to enter into back-to-back CFAs. From my experience now, I have no problem in going to a number of commercial sets and being offered a number of counsel who are willing to take the cases on a partial back-to-back CFA. I think 100% CFAs are a much bigger problem for any counsel in commercial matters, purely and simply because with a large firm of solicitors, risk is spread across a number of partners, whereas for counsel, the risk is all on one head. So there's a completely different dynamic. Going forward with next year, I think the big issue is on the saving provision. For insolvency cases, I think the saving provision whereby the CFA success fee is still recoverable, that's going to be there until March 2015. What will happen after that is an open question. Publication and privacy, defamation, again, what will happen there really depends on what comes out of the consultation process as to whether how quickly that moves into a QOX, qualified one-way cost shifting regime. I myself see huge difficulties, potential satellite litigation if that ever comes about. If you have this concept of a means test, whereby claimants are assessed as to whether they've got modest means, so they have no net liability for costs, some means, so they have a part or capped liability for costs, or substantial means, which means they have no cost protection, I can't see how that's going to operate in practice, and I think it's ripe for satellite litigation if ever it comes about. But I think it will do in one form or another. The government have made it clear they want to bring defamation claims, privacy and publication claims into a non-recovery scenario for CFA success fees. Mesothelioma claims, again, they're going to disappear from the recoverability of CFA success fees purely and simply because of the introduction of the Mesothelioma Act 2014, which in effect establishes a scheme for the payment of those claims, which in effect means the government will take them out of recoverability so far as CFA success fees are concerned. The success fee element, obviously, of any CFA following the revision in the rules in 2013, well, that clearly is something which is roughly 25% in first instance cases for PI claims, 100% in all other claims including PI appeals. DBAs, damages-based agreements, another area whereby lawyers agree to share risk. Damages-based agreements, they've often been known as don't bother agreements, but whether you want to call them don't bother agreements depends on whether you really think they work. There's some huge problems with them. Everyone knows the DBA fee has to cover solicitors' fees, counsel fees and VAT, whether or not your client's VAT registered or not. It creates a huge problem. No lawyer can operate. Very few lawyers are willing to go anywhere near a DBA.
Have you heard of any lawyers that have?
I know of one firm that say they have entered into one or two. The real problem is I think most people only look at a DBA in the commercial arena where the sums in dispute are substantial, and we're talking about multi-million-dollar claims.
Yep.
They just do not work for low-value claims at the moment. The issue of the sums only being paid from recovered monies, the DBA fee, not the expenses which are payable in any event, but the DBA fee, i.e. the solicitor's fees and counsel fees, VAT in commercial cases. In effect, lawyers, if they do a DBA, are taking on the solvency of the opponent, a big issue. There's the issue you can't do hybrid or partial agreements. Again, how that will be resolved going forward, we don't quite know. The MOJ apparently are listening to concerns, but listening to concerns and action happening, how quickly that will happen, I personally, I'm not holding my breath. I think we're a long way off from that actually taking place, and I wouldn't be surprised if the DBA regulations were not revised for at least another year. Some people have talked about DBAs not being possible because you can't put termination provisions within a DBA because there's nothing to do with termination within the DBA regulations. I personally have a doubt about that one because in effect there's nothing about termination in the CFA regulations, and that's never been an issue. No commercial lawyer is going to enter into any form of DBA or CFA or any other arrangement unless they can have a termination provision. And my view would be, and I have drafted DBAs, if I drafted a DBA, I would not enter into a DBA with a client without there being a termination provision. Otherwise, a savvy client may decide just at the last moment to decide he no longer wants a DBA, walk away from it, do a deal, and what does a lawyer do if he hasn't got a termination provision in his agreement?
Might it be quite difficult? Well, how the drafting of that, I could imagine, could be quite contentious, the termination provision.
Generally speaking, the termination provision in that type of agreement will be quite simply that if the client wants to terminate the retainer, and the client always has the right to terminate any retainer, if the client wants to terminate the retainer, the client just pays what's on the clock,
Yep.
base costs, quite simple. And the lawyer would not, if he's sensible, retain any other right under a DBA
Yep.
to take a percentage if the client then wants to go on and pursue his claim somewhere else. But most lawyers will want to be covered for their base costs in the same way that most commercial CFAs will include the same termination provision. You can terminate, but you pay me all my base costs if you want to walk away. You then move on to ATE, after the event legal expenses insurance. Another way clients can in effect hedge their risk. A client can insure against adverse cost liability, he can insure against adverse cost liability, he can insure his own disbursements, he can insure an element of his own costs. It's a way a client in effect can hedge the risk of bringing litigation. There are new products which have come on the marketplace since in the last year. It's all a bit grey at the moment. The type of products we're talking about are ATE policies where there's an excess. Obviously, if you have a large excess in the policy, it brings down the premium. So you might, for instance, have a policy which says you will bear the first $500,000 and any adverse costs, and the insurer only picks up the excess above $500,000. Substantially reduces the problem with commercial premiums, which has always been a big problem in any litigation, especially where the ATE premium is no longer going to be recoverable. There's a question of now some ATE policies will have payment up front or part payment up front of the premium. Again, it would reduce the cost of the premium because insurers, as they've never done before, will no longer necessarily defer all the premium, and by taking part of the premium up front, that reduces the cost because the insurer has use of their monies, as with most insurance policies, during the course that the policy is running. There's also a product on the marketplace whereby an insurer is willing to, in effect, take an ATE policy which is based on a percentage of recovered monies. So the insurer is in effect saying, I will take 17% of the recovery and the litigation as my premium. These are the type of products which just didn't exist before April 2013, but they're now in the marketplace. Lastly, the interesting development is third-party funding. And what I would say to anyone who doesn't know about third-party funding is, you should know about it. If you're not interested in it now, you're going to be interested in it in the next few years. Third-party funding, in my mind, is at the stage which CFAs were at 9-10 years ago. If you talk to commercial lawyers 9-10 years ago, very few commercial lawyers, except I would say for the savvy commercial lawyers, were doing CFA work. Now if you talk to commercial lawyers, they will talk about CFAs and DBAs as if it's common usage. They will enter into CFAs and they will share risk with clients. It's not an issue. Third-party funding is very much as CFAs were 10 years ago. I believe within the next 3, 4, 5 years, third-party funding will be mainstream. Third-party funding, totally non-recourse. The funder puts up the money, the case loses, it's the funder that loses his money. The big word that's never used in third-party funding is obviously the L word, the word loan. It is not a loan, it is pure non-recourse. What do funders look for? Quite simply, they look for merits, has to be a good claim. They're not talking about 60, 70%. They're talking about, do the merits mean this claim is going to win? Anyone can put a figure of 60%. It means nothing. It's whether the claim should be a winner. The next thing they look for is quantum. Most, and I say most, not all, funders are looking for substantial disputes to fund. And I'll come back to why in a second. It's because when everyone takes their cut, there has to be enough money left for the client at the end of the day. So you have merits, quantum, and lastly, recovery and enforcement. Funders are not in the game for Pyrrhic victories. They're in it for recovery, and there must not be any doubt that the opponent is good for the money, and there won't be an issue on enforcement. Funders will fund domestically, court arbitration, they will fund internationally. I've been involved in funded cases both domestically, in England and Wales litigation. I've also been involved in substantial funding packages in international arbitration. And what you do with a funder can be quite flexible. What are funders doing in the press? What have you seen reported? Well, if you want the reason why funding is so expensive, just look at the Excalibur Ventures and Texas Keystone and Gulf Keystone litigation. The funders there, the case crashed and burned. You've probably read about it in the legal press. So far, those funders have been made liable for 23 million in costs, and it's not finished, albeit that one of the main funders actually is no longer in existence. Funders take enormous risks, and in return, they take a profit. The leading funders have got a huge amount of money to invest in litigation. Burford Capital have got $300 million plus to invest in litigation in this country. The problem is for most funders is that they have not got the right cases to invest in. They've got lots of money, but not the right cases. They will not invest in bad cases. Lastly, I would say how things have moved forward. Well, 5 years ago, very few law firms would have specialist cost advice. You now see a new breed of person. 10 years ago, there was probably 2 or 3 specialist cost counsel. There are now, if you added them up, probably 30 or 40 counsel who say they practice in the area of costs. My practice, there are probably a number of people like me now who specialise and just provide cost consultancy services either to large commercial firms or externally by way of an external consultant to a number of firms. At the end of the day, what I would say is anyone who's in practice needs to have involvement of cost specialists. They need to understand litigation risk transfer. And the reason you need to understand it, quite simply, is litigation risk transfer creates opportunities for your practice. And opportunities for your practice means 2 things. It means you can increase fee income, and it means you've got certainty of fee income. And the question here is, I think, either you get on board the train, which is moving forward rapidly in relation to litigation risk transfer and funding, the involvement of third-party funders, external people coming in to fund litigation, you taking part of the risk with clients, involving clients with insurers, putting all these things together in different packages, because if you don't, I would suspect that in 5 years' time you will be left standing on the platform and the train will have been gone.
That's very interesting. Thank you very much. I've got a quick question. So that's clearly a growth area. Do you see that at some point actually supplanting the normal private fee charging arrangements?
I think for some commercial clients, yes, because at the end of the day, for instance, third-party funding will enable a client to litigate off balance sheet, which can be very important for some clients. Litigation funders don't necessarily just fund a dispute. They will actually buy into a claim. So for instance, you may have in a large scenario a $50 million claim. A funder may turn around and say they're never going to buy the whole claim because they want the client to have skin in the game. Otherwise, how do they get the right information? Where do they keep the witnesses on side? What that funder might be willing to do is, for instance, say, well, it's a $50 million claim. We will give you a $10 million injection of cash into your business now. We will put forward another $10 million to run the dispute, or $5 million, whatever to run the dispute, and then we will take X% of the return. Now, it has to be appreciated that depending on the nature of the financial arrangement, funders will be taking probably up to 35% of the result of the recovery in the litigation. The problem is, if the funder takes 35%, if the lawyers are taking their fees plus an uplift because they're under a CFA, if there's ATE insurance because the funder won't want to be covered for any adverse cost liability if it can occur, all those add to the cost of litigation. That means, when I came back to saying earlier that the funders are only interested in high value claims, the reason for that is that generally speaking, funders will look for a ratio of a minimum of 1:4, possibly 1:5, between costs and damages. So in other words, if the costs are going to be £2 million, to fund that matter, the funder would generally expect a £10 million recovery in the litigation. And the reason, quite simply, is they want to be sure, quite rightly, that by the time they take their cut, by the time the lawyers take their cut, the ATE insurer take their cut, the client has irrecoverable costs, that there's still a substantial sum of money left in it for the client.
Yeah, that's really interesting. Thank you very much. Should we go over to Ed?
Sure. I'm going to talk to you about the case, really, of the last 12 months, Mitchell and News Group newspapers. A case, a decision of the Court of Appeal on the 27th of November last year that has been very well covered in the legal press, and I'm sure everybody watching this programme will know all about. But what I want to start with, really, is to try and understand what's led us to the decision in Mitchell. And to do that, looking around my colleagues, I don't think I'm the only one who remembers the days of dismissal for want of prosecution in the 80s and the 1990s. Certainly as a young lawyer, I spent many a happy day trying to strike out perfectly meritorious claims for want of prosecution. Claims in which some lawyer had issued what was then a writ a dozen years or so before this application to strike it out, and nothing had happened in the interim. One of the things that Wolf was intended to deal with in the advent of the civil procedure rules in 1998 was that we would have active case management. Parties were no longer to be trusted. They were no longer to be allowed simply to run their own cases. Judges would keep control of their caseloads. And that, I think, explains the Baguzzi decision. Because Baguzzi, back in 2000, was Lord Wolf saying that going forward, striking out was using a sledgehammer to crack a nut. And then for the next 13 years, leading up now to the Jackson reforms, we really had a culture in which, however grievous the default was, however serious the breach, provided it was still possible to have a fair trial, and provided the defaulter could be hit and penalised in costs, it was often said that that was the appropriate remedy. As a result of that, striking out went very much out of fashion. And then along comes these Jackson reforms. Underlying the Mitchell decision, I think, really are two particular key aspects of those Jackson reforms. The first, and some of these got overlooked, I think, by many commentators, interested very much in the change to CFAs, to referral fees, the introduction of DBAs, QOCs, cost budgeting and all of that. But right at the beginning of the new rules, the overriding objective was, of course, amended. And if you look at that now, there's an additional requirement for the court to manage the case at proportionate cost. And secondly, to manage the case so as to ensure compliance with rules, practice, directions and orders. In addition, we've got the new Rule 3.9. Gone has gone that long 9-point shopping list in Rule 3.9. Instead, 2 factors, as well as all the other circumstances of the case, must be taken into account by any judge on an application for relief from sanctions. And if you look at them, they're both against the interests of the party in default. And they're the same 2 factors that have gone into the overriding objective. The court must now ensure that the case is dealt with efficiently and at proportionate cost. Against your interests, as I say, if you're the one that's required all of this satellite litigation to undo your default. And secondly, the court must ensure compliance with rules, practice, directions and orders. Almost as if discipline for the sake of discipline now has a role to play. So that's how the rules changed. Notwithstanding that, many commentators, myself included, did not necessarily think that that led inexorably to the toughness of the Mitchell decision. I'll very briefly summarise Mitchell because it is very well known, but there, famously, the MP Andrew Mitchell was late with his cost budget. He got it in the afternoon before a case management hearing before Master MacLeod, and what she did the next day was to impose a sanction that he be limited to court fees. It wasn't actually under the new rules, but she, by analogy, used the sanction under Rule 3.14. And the Court of Appeal case was about whether or not that sanction ought to have been imposed, and secondly, whether relief from the sanction ought to have been given. And the answer, as we all know, was a resounding no. The Court of Appeal say, first, that you must analyse the nature of the default. If it's purely trivial, then provided you also make your application for relief promptly, you will be okay. Absent that, you need a good reason for your default. And they were very clear that pure oversight, human error, pressure of work, all the sorts of things that were prayed in aid over the last dozen years will no longer be good enough. And that is why this decision really now, pardon me, imposes a far tougher regime for those who find themselves in default. What the Court of Appeal also did, though, was to stress the importance of making a prospective application. If you find yourself unlikely to be able to meet a deadline, it's absolutely critical now to make an application before the deadline passes, rather than to try and bring yourself within this far tougher regime for relief from sanctions. But to understand fully the cultural shift, I think you need to understand that the Court of Appeal in the Mitchell case accepted in terms that their decision was harsh as far as Mr. Mitchell was concerned. The word prejudice, you will note, is missing from the test that was espoused by the Court of Appeal in that case. And this perhaps is the more chilling aspect of the Mitchell decision. Lord Dyson specifically endorsed his own observations about the new Jackson reforms in the 18th implementation lecture. And that was one of the more hard-hitting warning bells that we all got as professionals in advance of Jackson. And what he said in that lecture was that the court would now be looking to do justice in the majority of cases. And he went on to say that justice now means something different. So gone is the idea that on a relief from sanctions application, one purely looks to the justice as between the defaulter and the innocent party, to questions of prejudice, and then decides whether or not a fair trial is still possible. That old-fashioned approach has gone. Instead, the new approach is really about promoting the efficiency of the system, understanding that Wolfian justice was too expensive, that Wolfian justice was too indulgent, and that under Jackson, as interpreted by the Court of Appeal in Mitchell, things are getting a lot tougher, and there's a far greater focus on the overall efficiency of the system and the justice to other litigants. that unnecessary applications for extensions and relief from sanctions clogs up court lists and has an impact on others, and therefore they are to be stamped down on. But most dramatically, you see in the Mitchell decision criticism of, for example, a decision of Mr. Justice Andrew Smith. And at first blush, the criticism seems quite surprising. A criticism that what Mr. Justice Andrew Smith had done was focus exclusively on the question of the justice as between the parties. He might have thought that was him complying with his judicial oath, but what he's told in that case is that that was wrong. And interestingly, we've now had in the last month another decision from Mr. Justice Andrew Smith in the Commercial Court, in which he has effectively said that if I were deciding this case purely on the question of what is fair as between these parties, I would grant relief. But then he says what he's constrained to do by Mitchell. He faithfully applies the Mitchell test, and he comes to a decision which implicitly he is accepting is not actually the fair decision as between those litigants. And that really is the power of the Mitchell decision. And it's why, at the moment, at the time of filming, and no doubt at the time also of watching this, it's a fairly feverish time. Many lawyers, I think, are very worried about being Mitchelled, about the consequences of missing a deadline. And to an extent, if what all of this does is makes all of us even more careful and prudent and manage our cases more efficiently, then great. But I think there's great concern that some injustice will be done to individual litigants along the way.
Ed, very briefly, what do you think about that decision and the fact that Andrew Smith actually said that on fairness he would have liked to have decided this way, but he felt constrained to decide another way? Do you think that's appropriate, or how do you feel the difficulty was placed in?
Well, he has got to follow Court of Appeal authority. And I think he was absolutely right to apply the Mitchell test in the way that he did in that case. And indeed, other judges are now being constrained to do. But I mean, an interesting decision, I think, is the decision of Mr. Justice Leggett in the Summit Navigation case. Another of the recent cases, a February case, decision of Mr. Justice Leggett, again in the Commercial Court, suggesting that not all breaches of orders are necessarily the same. And indicating that in appropriate cases, and he felt the one before him was such a case, that he didn't actually have to apply the Mitchell test. As at the day of filming, that case is yet to be referred to or relied upon by another judge. But it may be interesting to see whether there is this third way in cases of fairly technical breaches where there is no prejudice, but even if the breach is trivial, you haven't necessarily been prompt in your application. Is there another way in that type of case? And I think the next few months will be interesting to see whether another option opens up.
Do you think that the pendulum is slightly shifting then, ever so slightly away from the initial strictness of Mitchell?
I think judges are looking for, and certainly I get this from colleagues and my own experience, going around the country to various applications, that judges are looking for a way in appropriate cases to give relief from sanctions. I think that's inevitably right. I don't think they necessarily like being constrained along a very narrow path. But there is the Mitchell case. They must follow it and apply it. And I think we are therefore seeing far more strikeouts, far more people being held to their court fees, the Mitchell sanction, and other types of sanction being imposed. And a number of cases now where the courts are depriving people of their witness evidence because of their failure to lodge that in time, to serve it in time, and therefore applying the default sanction under Rule 3210. So yes, we are seeing a lot of tough decisions being made, but I think there are quite a lot of judges out there who are not keen on doing it. One way potentially around this, it's already been trialled in the Royal Courts of Justice. The masters in clinical negligence work and in mesothelioma cases are starting to give some bespoke directions. And those directions are saying that provided the parties agree, and provided it's not going to impact upon a hearing date, they can agree an extension of a direction for up to 28 days or 21 days in mesothelioma cases.
That is interesting. That's a very nice way of...
Potentially, yes. There is a technical problem with it, in that Rule 3.8 tells you that the parties cannot actually agree an extension of time where a sanction is imposed. And if, for example, it's witness statements, there is a sanction. It's Rule 32.10, tells you the sanction, that you can't rely upon those statements at trial. So there is a technical problem with that. I can share this, that the Rule Committee is looking at this point right now, and it is possible, but not yet decided, that there might be rule changes in order to allow that type of direction, or even perhaps to build such a direction into the rules themselves. But in my last couple of minutes, if I may, can I tell you, the audience, about another key development that's just very hot off the press, and I'm shifting now, if I may, to costs budgeting, and that's that from the 22nd of April, just around Easter time of this year, the work of the subcommittee reviewing cost budgeting has now been completed, and the Rule Committee, subject to the sign-off of the Lord Chancellor, so it's not yet in sort of bold print, has decided that the commercial court exemption will go, that the £2 million value-based exemption will go up to £10 million, but applied now to all courts. And therefore, from the 22nd of April, all multi-track Part 7 cases will be in cost budgeting if they're worth less than £10 million. Above that amount, they will be excluded. But there is a new Practice Direction 3E, and that's greatly expanded. And one of the things that will do is it will indicate the virtue of the parties or the court nevertheless making a cost management order. And parties and courts are particularly encouraged to do so in a certain number of types of case. Unfair prejudice petitions, not Part 7 claims, but thought to be suitable for cost budgeting. Equally, disqualification proceedings of directors and the like under the Company Directors Disqualification Act. Talata claims, and also inheritance and dependency claims, all thought to be suitable for cost budgeting. And although not Part 7 claims, there's a good steer in the new practice direction that the court should think seriously about bringing those in. Thank you.
No, fantastic, and a great piece of news at the end there, that we find out what was long suspected about the new exemption, which
yes.
is good to hear. Thank you. Okay, finally, over to Mark Sergi, who's going to be talking to us about disclosure and other sorts of practical matters which are facing solicitors. So over to Mark, thank you very much.
When looking at Jackson, of course, we're talking about costs, and Ed's just mentioned their costs budgeting. Cost budgeting is really about the costs between the parties. But what about the costs that are being incurred by the process of litigation itself? And I think if we want to look back over the last 12 months at what's happened since the Jackson reforms started to change the way people think about their litigation, we probably won't see a great deal of change in just that 12-month period. But if we look back to the history of the reform of civil litigation, which goes back to the mid-1990s, we see a clear trend that has been slowly beginning to influence and change practice. But it is slow, and there are only 2 cases in the last 12 months that I can refer you to that specifically relate to the new Rule 31.5. But before we come on to those, let's just turn the clock back a little bit to the Wolf reforms in the 1990s. Because even then, Lord Wolf, in his recommendations for bringing in the CPR, and in particular the overriding objective, was concerned about the complexity of modern life, and his consultation actually revealed that there was an increasing tendency then to record things in writing. Look how far things have gone in that 20-year period now in terms of complexity of commercial life and business life, and also the whole question of written records. We now have the internet revolution and the information technology revolution, which has meant that virtually everything that's said is now being recorded automatically in some form. Even in the final report the following year in 1996, it was absolutely clear to Lord Woolf that something had to be done to curb what was then referred to as discovery. And from that moment onwards, there's been the underlying and indeed explicit policy objective to limit the discovery, the disclosure as we now call it, in the English system. And it's been contrasted very much with the continental system where there is no disclosure, and it was even recognised by Lord Woolf that there was the possibility that disclosure as we have it in the common law system could actually be abolished if it couldn't be managed. Lord Woolf also recognised in doing the research that he did for his reforms that there was the risk that parties would seek to conceal relevant information, and that tension between wanting to make a perfection the enemy of the good, which is a phrase that he used in his final report, and also the strategic and tactical objective that some parties have in litigation to conceal information or suppress information that might be damaging to the case, actually characterises most adversarial litigation even now 25 years later. What about the Jackson reforms then? What happened to the question of limiting discovery disclosure then in relation to what Woolf was doing and where we've come to today in 2014? Well, Lord Jackson actually didn't say a great deal in his final reform report about disclosure itself. He did say something about electronic disclosure, and we do now have a new approach. The new approach actually isn't new in the sense that the commercial court at the time was and still is operating a menu approach to disclosure. And that approach is essentially a non-commoditisation approach. It is a tailor-made approach for every case that comes before the court, bearing in mind the nature of the case, what's in issue, the amount at stake, what is the appropriate and fair and just way of dealing with the disclosure process. And Lord Jackson looked at 8 different ways of tackling disclosure, and in the end he settled on the menu approach, which of course gives maximum flexibility to the parties to themselves choose the most appropriate solution for their problem. What Lord Jackson did do in the new Rule 31.5 was to abolish the default option of standard disclosure. And standard disclosure had been Lord Woolf's attempt to limit the excesses of discovery in the pre-1999 regime. So what we had from Lord Jackson in relation to e-discovery was he appealed straight away to the practice direction 31B as it now is, which was undergoing reformation at the time of his report, and described that as an excellent practice direction and a great tool. And that surely is the starting point now for any piece of litigation, given that there is very little distinction in practice between disclosure and electronic disclosure. The two should not, in my opinion, be seen differently. They should be seen together as the same problem that has to be tackled, and that is the problem of how do we manage these huge volumes of data, how do we limit that disclosure process whilst at the same time enabling parties to have their cases decided fairly. What Lord Jackson did say, and this is really the essence of his reforms, was that there needed to be a greater level of education amongst practitioners like myself, barristers like Ed, and the judiciary. And I have to question, 12 months on, to what extent that extra education is really happening in practice. I do see it happening, and I do think some law firms and some practitioners have taken it upon themselves to really get into the issues that the practice direction tries to tease out, which we'll come on to in a second. But I think that process of education has not accelerated maybe to the degree that it should have done. There's been a lot said about the lack of training for the judiciary, and although we do have some fantastic judges who sit in the more complex cases in the commercial court, who are very well versed in the technology and of course in the TCC as well, perhaps in other parts of the judicial system that level of knowledge still remains to be improved.
Mark, a quick question on that, sorry to interrupt. Do you find that when you are acting on cases in practice that the other side doesn't engage in PD31B at all, as in, for example, how often is metadata discussed in cases? Is it ever mentioned specifically, metadata?
PD31B is all about the parties cooperating and communicating with each other, and that's the underlying solution to the disclosure problem. It's discussion between the parties. It's for the lawyers to solve the problem, if you like, for themselves, and in the last instance to go to the court, or otherwise ultimately forfeit the freedom of having civil law, common law rather, disclosure. Do we see parties communicating with each other? Well, I think we've seen more attempts to use the electronic documents questionnaire as a tool. It's certainly not a compulsory tool, but it is a useful starting point as a checklist. Really, the Practice Direction 31B is saying to the parties on both sides, you need to understand the technology, you need to be having discussions about the technology that's available. You need to be having discussions about how you can limit disclosure. It's about limiting disclosure, not expanding it. It's about how can we do this case with the minimum amount of information that is fair to both parties. And there's also a theme in there about discussions around sharing costs. And whilst, to answer your question, Neil, it may be true that there are some discussions about metadata, there are probably very few discussions that I'm seeing about how can we share the costs. For example, how many times are people suggesting that they share a review platform and share the costs of doing that? That would be a very efficient thing to do. Keith's talked about litigation costs funding, and I'm sure the funders would be interested in seeing cases being handled in a streamlined and efficient manner in order to achieve the best results. The other thing that the Practice Direction does is warn about the dangers of using keywords. And one thing that I have seen in the last 12 months, as indeed in many of the same period before that, is still an over-reliance on keyword searching, which in my experience is a very blunt instrument, to quote that phrase from one of the American judgments, but also a not very effective way of using automated search functions. And the beauty of electronic information, of course, is that you can use automated searching functions. And we will see a move. I think there's very little move in this direction between the parties at the moment, but we will see a move towards technology-assisted review, or predictive coding as it's sometimes called, or as I'm now referring to it, artificial intelligence, where the software will learn from the practitioners and will do the searching largely for itself. What have we seen then in the last 12 months in terms of specific cases around Rule 31.5 then? That's the new rule that came into effect from the 1st of April 2013 and requires the court in all multi-track cases, non-PI cases, to not apply standard disclosure as the default option, but to look at the menu. Well, there have been two cases, one extremely interesting case and one case to note. The first one to note is that the Intellectual Property Enterprise Court has decided quite emphatically that Rule 31.5 does not apply to proceedings in that court. And that's a very simple point and very straightforward, and if you're a practitioner in that court you will know that that is the regime there. Outside of that particular court there has been one very interesting case where one might think that some pause for thought has now been injected into the debate in relation to the menu option, and it's the case of Royal Bank of Scotland versus Highland, a very complex piece of litigation in which we've been able to see, because in one of the second phases of the case the solicitor-owned client privilege was waived and Peruvian Garno-wide discovery was ordered because there was a question of fraud. But what that has enabled us to see is that the strategy in that case for the claimant was to give as little discovery as possible as was consistent with the obligations of the parties. And a split issue was determined to apply for summary judgment on liability and leave questions of quantum for another occasion. And what actually happened there was that documents that probably were relevant to the liability issue were able to be concealed into that second quantum issue, so much so that in the end the Court of Appeal determined that even though summary judgment was granted to the claimant, it should be set aside on the basis that it had been procured by fraud. And that's not the point I want to focus in on, but I want to focus in on a very short judgment of Lord Justice Maurice Kay in the Court of Appeal in the latest chapter in that particular piece of litigation, which is ongoing in the US at the moment. The main judgment was given by Lord Justice Akins, and he deals with all of the issues of setting aside of the judgment and anti-suit injunctions and the like. But Lord Justice Maurice Kay issues a warning, and he specifically refers to Rule 31.5, and he says, and he endorses the approach, that there will be more issue-based disclosure orders being made in the future. Issue-based disclosure being one of the number of different options under Rule 31.5 the parties can choose. But he said there was need for circumspection, obviously having mind for what had happened in the case before the Court of Appeal in this instance. He thought that there was a real danger that when issues-based disclosure is ordered, there is the real opportunity for relevant material documents to be subordinated into an issue B, or as he calls it, or a subsequent issue, that really ought to be included in the first issue. And
especially when there's mixed issues, I imagine. When there's mixed issues in a document, it would be easy to take a judgment call and imagine that it's mainly about issue B, to put it into issue B and defer it.
It was certainly a tactic in this case, and one can't say that it was an illegitimate tactic, perhaps, on the face of it, to devise the strategy into issues and to put some of the more damaging documents into an issue that will be decided later, in the hope, no doubt, that the case could be settled beforehand. And what the Court of Appeal seems to be saying now is issues-based disclosure is good, but let's just be aware of the possibility for manipulation. And it's very, very rare that the courts do comment on underhand tactics in litigation. As I mentioned earlier, Lord Wolfe was aware of the possibility of documents being concealed and material documents being concealed in litigation, and one of the fears of limiting the breadth and the scope of disclosure, as has now been the case, is that some of those material documents can somehow be hidden or maybe postponed. And I don't think we will see the end of those types of strategic approaches to disclosure and the menu option, but it's a sobering thought that although we are moving to a more limited phase of disclosure in order to curtail costs but still maintain justice, I think what Lord Justice Maurice Kay was saying was he didn't want issue-based disclosure to become a framework for injustice, was the very kind phrase that he used. And I think I would read that as a warning shot to practitioners, just to be careful about underhand tactics, just in the same way as we've experienced in the past document dumping, with huge volumes of irrelevant documents being disclosed to a party in the hope that they run out of money reviewing them. So I think in summary then, the course of the last 12 months is a continuation of a very long trend now of trying to limit discovery, now disclosure, in the common law world in this country. We have the overriding objective which underlies the whole approach to disclosure, and although Ed is absolutely right that the overriding objective was amended as part of the Jackson reforms, it is still the case that the word proportionality formed part of the original overriding objective, and that is certainly a key part of disclosure, as it was 15 years ago and it is now, but it's not the only element of it. It's about cutting your coat according to your cloth, but also tailor-making the solution. There are some warnings that the new approach may be the subject of some abuse, and I hope that we won't see cases of practitioners being chastised for doing that in the future, but it is perfectly possible that we may see that. And in the meantime, I hope that we will continue to see further engagement between opposing lawyers around the use of technology, looking at ways to share costs, looking at ways to limit disclosure in a way that is fair, and probably making those decisions between them without having to trouble the courts too much to decide those issues for them. The courts don't like disclosure disputes, they never have done. It can be a very rough and ready means of settling those problems, and I think it's for the parties to cooperate. And I hope that opposing law firms will start to have the confidence to consider a case using technology-assisted review. The information I have from talking to colleagues in the marketplace is that everyone is waiting for the first case where the judiciary will approve the use of that technology, and I'm sure it will come. It's happened in the US, and it's only a matter of time before it happens here too.
Thank you very much. Fantastic. Really, really helpful. Thank you, Mark. Okay, we're almost at the end of this webinar, which I think our watchers will agree has thrown up some really useful tips, some practical tips, key issues over the last 12 months. I know you've all touched upon the next 12 months briefly, so I don't necessarily want you to repeat yourselves, but could you maybe each have just suggest a nugget as to what you think will be a key issue over the next 12 months? So we'll start with Keith.
The key issue for me is whether or not the MOJ decides to allow or to rewrite the DBA regulations. The rewriting of the DBA regulations will free up lawyers to really engage in proper risk sharing, in pure contingency, hybrid contingency agreements. That's what Jackson wanted. He wanted a sharing of risk. He wanted litigation funding to be a relatively open playing field, in effect to reduce the cost for clients and to facilitate access to justice at proportionate cost. That's what I hope will happen more during the next 12 months.
And with a rewrite, do you think there could potentially be an explosion in take-up? Clearly, it would be better than it is now. Do you see it as being an amazing new means of funding?
DBAs are not totally inoperable at the moment. There's just huge problems around them. There would be a huge take-up in funding, in particular in the international arena. International clients understand and appreciate contingency agreements. They find conditional agreements more difficult as a concept to understand.
Brilliant. Thank you. Ed.
I'm going to be greedy and take two. The first is, I think that Mitchell will settle down. I think that we will get back to parties cooperating in terms of sensible extensions of time, certainly if they're sought prospectively, and I think the rules may in due course help us to achieve that end. My second bullet for what's on the horizon is that there is a root and branch review of Part 36 underway, and I think that over the next 12 months we can see major things happening in terms of Part 36 reform.
Thank you very much. Okay, and finally, Mark.
I won't try and trump Ed, but I will take two as well.
Take three if you like. You can have three. You can have as many as you like.
I think first and foremost it has to be recognised that the problem of document volumes isn't going to go away. Corporates are generating huge volumes of data as we speak, and that issue has to be grappled with. I think that we will see more and more e-discovery, if I can use that phrase, projects going wrong because they are hugely problematic, they're very risky and they're difficult to deliver. And I wouldn't be surprised if we see some further embarrassment in the law reports, and we may even see some professional negligence cases, and I think we will see specialist professionals being able to come in and sort out projects that have gone wrong. Secondly, I think that machine learning and technology assisted review and the use of computer software to carry out some of the trawling and searching of these huge data sets has to develop further. The software is developing. I think its use needs to develop further, and I think I will take the third point, and that is this, that parties must continue to cooperate in solving these problems. I think there is a whole ethos of cooperation in the way that Ed has mentioned. I expect we will see more of that, and we would certainly want to encourage it. I think it's a sign of confidence in your case that you can have a conversation with your opponent around procedural matters and reach agreement or not agreement as the case may be without showing any weakness at all in the underlying merits. And I know the bar are very good at having those sensible conversations, and I think solicitors need to have a few more of those.
Thank you. You took up the third point, so I'm going to take the opportunity to ask you one quick question, and that's the machine-based learning that you mentioned. Solicitors, by their nature, are very cautious creatures. Do you see... if I was back in practice, I would still worry about missing something employing machine-based learning for the disclosure process. What do you feel about that?
I think it's okay to miss things. I think providing a proper approach is being taken and you can defend it. It was already stated by Mr. Justice Morgan in the Digicel case that it's not necessary to turn over every stone. I think Lord Walford already made the point that we shouldn't let perfection become the enemy of the good, and I think it's about proportionality, not about perfection. The meaning of justice is changing, Ed, is that what you said earlier? Indeed. And I think that's to accommodate the changed environment that we're in an information revolution, and I think it's having a proper approach, and if you miss something, well, that's just one of those things.
I think that's a fantastic opportunity to close. There were some useful phrases there being thrown around, so thank you very much. Thank you, watchers, for joining us. I'm sure there'll be another update soon. Thank you very much.